Hi, everyone. Thank you so much for being here. My name is Greer Luce. I'm the Curator of Education and Public Programs here. Can you not hear? Sorry. Is that better?
Yes. Oh, that's wonderful.
Sorry about that. Welcome, everyone. My name is Greer Luce. I'm the Curator of Education and Public Programs here at Morven Museum and Garden. I'm so happy to welcome you to the fourth program in the So You Think You Know Civics series. Tonight's topic is what is law? We started this series in April 2024 with the goal of engaging communities in conversations around democracy and civics leading up to the 2024 general election and the 250th signing of the Declaration of Independence, the 250th anniversary of the signing of the Declaration in 2026. We're so proud to partner and collaborate with the Princeton Public Library on this series, which is co-sponsored by the New Jersey Council for the Humanities. The series so far has sought to unpack big questions about the past and present of the US government. We've tackled the questions, what is democracy? What is citizenship? What is civic participation? Tonight we're going to address what is law with speaker Dr. Tao Dumas. This topic tonight is particularly relevant to Morven. The first two generations of Stocktons who built this house and lived here were actually lawyers. So it's a topic that's particularly close to us here. A quick plug to please don't miss our fifth and final program in this series, scheduled for November 13th with Dr. Saladin Ambar, Senior Scholar at Eagleton Center on the American Governor and Professor of Political Science at Rutgers University, New Brunswick. This program will tackle the question, what is political leadership, 1 week after the general election. So this is your friendly reminder to please vote. Before I introduce tonight's speaker, I'd like to invite my colleague, Cliff Robinson, Public Humanities Specialist at the Princeton Public Library, up to say a few words.
Okay, thank you, Greer. So I'll keep this very brief so we can get on to what we're here for, but I just wanted to thank you for being here. Thank you for being online. And I also want to thank Dr. Dumas for coming tonight to speak to us and engage on this very important topic. And thanks to the Morven Museum and Gardens and to Greer Luce in particular for carrying this series of programs through so elegantly. Thank you very much.
And one housekeeping note I do want to mention, I know we have quite a few folks online. I will be monitoring the Q&A box on the webinar. So when we have Q&A, please feel free to type in your questions and I'll try and get to those on the mic here. I'm now thrilled to introduce our speaker for tonight's program. Dr. Tao Dumas is an associate professor of political science at the College of New Jersey. Prior to that, she worked at the University at Albany, SUNY Albany, and the Louisiana State University Law Center. Her research focuses on the US courts and the ways lawyers shape and work within the legal system. She is particularly interested in how institutional differences across states condition winners and losers in the courts, and how attorneys' experience, expertise, and demographic characteristics impact their legal practices. She also serves as the coordinator for the TCNJ pre-law program. Please join me in welcoming Dr. Dumas.
Good evening.
Good evening. Thank you for being here.
Thank you so much for coming. So my plan for our conversation tonight is to start out by talking about how legal academics and the way that they have thought about the law has changed over time. And so I wanted to talk about these frameworks because they give us a perspective for thinking about the law and evaluating what it does. And I hope that that will then lead us into an interesting discussion because concepts and debates about what the proper role of law is and should be in our society, who makes the law, who should be following the law, whether or not we should follow law that we disagree with, are all really valid questions that we're having as a society. So I thought it'd be really interesting to start with thinking about what law is, and then how our thinking about that topic has evolved over time. So to get us started, we need a basic definition to answer the question, what is law? So we're going to start talking about some things that if you haven't had some advanced interaction with the law, you probably haven't heard of before. You probably did in a civics class a really long time ago hear about William Blackstone. He is a famous English jurist who wrote commentaries on the laws of England. It is the most famous attempt by a jurist to write down a summary of what English common law looks like. And so, given that the English common law tradition is largely the backbone for what we have, I think it's useful to start with Blackstone's definition of law. So Blackstone says, law is that rule of action which is prescribed by some superior and which the inferior is bound to obey. I really like this definition because it's short, but it also really does a lot. So, things that Blackstone's definition suggest. One, that law governs behavior. Two, I guess my numbers didn't come over when I emailed it to you, but that's fine. That's two. So, law comes from and denotes authority. So to have a superior and an inferior suggests that law is coming from an authority figure. The other thing that the definition suggests is that law actually creates and enforces a social hierarchy. That to have an inferior and a superior, you have to have some sort of hierarchy of who the authority is and who has to abide by that authority. And so a lot of the conversations eventually come to be about this question, about hierarchies in the law, who's making them, and who's following them. So we're going to fast forward a lot after Blackstone and think about some legal frameworks for thinking about the law. So the first one that we really relied on in the US legal academic tradition is what we talk about as legal formalism. And so legal formalism is this idea that law comes from an analysis and facts, and what judges are doing when they make decisions is they take the facts of a case, they apply some analysis, and they come up with a legal rule. So this really was the dominant way of thinking about law from about the 1870s, from the time we became a nation, to about the 1920s. And while this may be what we actually hope judges and jurists are doing, by the 1920s we began to really question whether or not this is what lawyers and judges and the law was actually doing. So the first group of people to question whether or not legal formalism, what was actually happening, are the legal realists. And so legal realists start to argue that law is shaped by social and political forces, and that judges are doing more than simply applying analyses and facts, that who they are, their values and beliefs matter. So most famously, you have a quote from Justice Oliver Wendell Holmes. So he's probably your most famous legal realist, where Holmes says, judges first find a result that reflects their own personal prejudices, political philosophy, or public policy preferences, and then find a rule that supports and justifies their personal viewpoint. Yes. So rather than the rule being how you get to the outcome, he argues that judges actually start with the outcome and then find a rule that justifies it. It's also coming from a Supreme Court justice, so pretty powerful statement here. At the time that Holmes was saying this, we were in a world dominated by legal formalism, where this was actually a pretty radical statement. I think, judging from my undergrads these days, this actually is no longer a particularly radical statement. But what the legal realists do is they usher in a much more critical study of the law, where people become interested in how judges are actually making decisions, whether or not their policy preferences, partisan identities, and backgrounds impact their rulings. And we also become interested in how the law impacts people in fact. What is it that the law is actually doing in our society? So, after the legal realists start challenging the idea that this is all just rational analysis, you get this idea about what role is the law playing and what role should the law play. So one of the first big groups to come up with a legal framework for this are these people who call themselves crits. What you have in the picture are some of the founders of the critical legal studies movement, both of whom are retired now but still writing in this area. And so the crits say that we really need to think about what law does. And so they really start writing on this topic in the 60s and 70s. It initially originates out of Harvard Law. And so what they say is that law and politics are inseparable, and that thinking of these as two separate things is not what they do in reality. That legal scholars are just as much involved in the political process as members of Congress or state legislatures. And so if we're going to be honest, we need to acknowledge that there is no real division between law and politics. They're also really interested in how the law perpetuates economic inequality, which brings us back to this idea of hierarchy. And so the crits said that the haves come out ahead in court and in the law, and that the law is structured in such a way to ensure that the haves come out ahead. And so they were very concerned with the ways that law created economic inequality, and that inequality was baked into the actual legal system itself. And so those in power, if you're going back to Blackstone's definition, were the haves, and they were creating the laws to benefit themselves. And so while we think of the law as this great equalizer where the have-nots can have their day in court, a lot of these scholars were arguing that's not what actually happens when you get there. What happens is that the haves have this baked-in advantage because they created the law in the first place. So following the critical legal studies movement, you get a lot of other critical arguments and frameworks for thinking about the law. The other thing that begins to happen in the 1960s and 70s is that lawyers in the legal academy begin to diversify. And you start to see women and people of color entering the legal profession and becoming legal academics. And they start critiquing other hierarchies in the law. So one of the prominent critiques becomes feminist legal theory. And so the woman pictured there is Professor Catherine McKinnon. She's currently a professor of law at the University of Michigan. She is very famous for something called dominance theory, where she talks about how the law was created by men to protect men and their interests. And she argues that the law deliberately sexualizes women to ensure that they continue in an inferior position in society. And so she's one of the famous feminist legal theorists. There are many others. But this really begins in the 1960s when you have the women's rights movement And you start seeing this expressed in the legal academy. And so they argue that the law is creating a social hierarchy that perpetuates patriarchy and inequality among the sexes. And so this is an argument that men are the ones making the law, that women have to follow, and men have created the law such that it creates a gender and sexual hierarchy in the law. So after the feminists begin critiquing the law, we have another version of the critical legal studies movement, which is critical race theory. So I want to talk about critical race theory tonight because there are states where it'd be illegal for me to tell you about this. And I think any idea that's worth banning is worth talking about. So the man in the picture is considered to be the father of critical race theory. His name is Derek Bell. He was the first Black law professor at Harvard. He also was a prominent civil rights lawyer prior to joining the faculty at Harvard. And so what happens with critical race theory is that it really becomes prominent around the 1980s. But it was because civil rights lawyers like Bell had become disillusioned with the law as a vehicle for racial equality. So Bell famously litigated in his civil rights lawyer days school integration cases. And so the attorneys like Bell at that time believed that if we integrated schools, that would be the path for Black students to have equal access to education in the South. And so they thought that the systematic underfunding and undersupporting of schools for Black students would end if Black students and white students were the same school. So you couldn't have these underperforming, undersupported schools if everybody was going to them. But Bell cites the example of winning cases where they got integration orders. And then what happened was that white families either moved to the next city or they put their students in private schools. And they developed new private schools. And so at the end of the day, what happened was they won the cases, but Black students in many places were still going to largely segregated and underfunded schools. And so that really is part of what inspires Bell to start thinking about the way the law perpetuates racism. And so what Bell argued was that racism reasserted itself after legal victories and took different forms. And so you could win in court, but that didn't mean that you were actually going to win in person and get the thing that you were after. Bell also says that the creation of many race-neutral laws on their face look like they're creating equality, but meanwhile what they're really doing is they're leaving the unequal system that existed in place. The other really important piece of the argument is that if the law is perpetuating inequality, you could have racially unequal outcomes even if we got to the point as a society that racist individuals cease to exist. It's a pretty bold statement, right? We could get to a point in our society where if nobody harbored any individual racist beliefs, if we didn't fix the law, you'd still see these racially perpetuated outcomes because it had been baked into the law. And so also thinking about our definition, you have people creating the law with the intent to bake in racial hierarchies. And there are ways that you could have seemingly race-neutral policy, but that actually don't change anything. And so at its core, that's really the core argument of what critical race theorists were interested in. How the law perpetuates that hierarchy, even when the law itself appears to be racially neutral. So, Kimberly Crenshaw is a professor of law at Columbia and UCLA. I'm not sure how that works, but I've been dying to ask her. I wonder if maybe she teaches in New York one semester and in Los Angeles the other, but I guess when you're as famous as she is, you have these options. So you may have actually heard of her. If you have not, you probably have and you didn't realize it. So Crenshaw was actually a student of Bell's at Harvard. And so Crenshaw was involved with the critical race theorists at Harvard, but she was also involved with feminists at Harvard. And the joint experience of that got her thinking that both the feminists and the critical race theorists had overlooked the way that the law and both movements had failed to include the experiences of women of color. So her argument was that if you are a woman of color, you not only experience being discriminated against because of your sex, but you also experience racism. And there wasn't a way in the law or in either of the sets of theories to address what she saw as that problem. So her argument is that if you are members of more than one marginalized group, you are experiencing multiple of these different hierarchies simultaneously. And so she comes up with the very famous term that you've probably seen that's called intersectionality. And so intersectionality is pretty much everywhere these days. We talk about it in our policies, we talk about it when we're making laws. And so intersectionality is a term that's become very widely used, but it actually comes out of someone participating in both the feminist and critical race theory movements and finding that they did not address her experiences or the experiences of others like her. And then the most recent one of these frameworks is queer legal theory. So around the mid to late 1980s, what happens is that you get scholars who say, well, the law not only has all of these other hierarchies we've already talked about, but they've created hierarchies for people based on their sexual orientation and their gender identity. And once again, who's creating the law that others have to abide by? And so this was also an argument about how we break down those barriers to entry for people also. And so you have across the top a number of the very famous scholars associated with the queer legal theory. So all of these frameworks are dealing with who makes the law, who's impacted by it. And I think what's interesting is all of them are dealing with this idea of a hierarchy. So what I wanted to from these frameworks is transition to some questions that I have, and then also take any questions that you might have. So to me, I think these are the questions that remain. Questions about who creates the law, questions about who should have that authority. And so a lot of discussions right now about whether or not we want to reform the Supreme Court or change rules to Congress, all of those are questions about who we want to have that particular authority. I think we're also having dialogues about what is just law, which all of those different frameworks and legal movements we're talking about. We also have questions about whether or not if a law is unjust, whether or not we should actually be following it. But the one that I think is actually the most interesting is whether or not it's possible to create order and social equality simultaneously. So if you go back to Blackstone's original definition, Blackstone suggests that part of what law is there to do is to control behavior. We all want to live in an environment and a setting that is ordered and safe. But Blackstone also largely suggests that you have to have some form of hierarchy in the law for the law to have impact and effect. And so I think it raises a really interesting kind of paradox that he seems to suggest that you almost need a hierarchy for the law to have the intended effect, But it does make me wonder whether or not there's a way that you can get to that effect without having the types of inequalities that all of these different versions of legal academics and legal academic thought have identified. So that is where I wanted to leave this discussion. But I'm happy to talk about this or anything else you want to talk about.
So we have time for questions. So I just want to remind folks online that I do have my laptop up as well. So if anyone has anything they want to put in the Q&A box or the chat, please do so.
I would like to know about, in a couple of your slides further back is, wait, what did you say it was, a neutral? Was it racially neutral law? Could you give an example of a racially neutral law? Like nobody can jaywalk?
No parking aside.
So, I mean, I think one example that Bell would point to is in a lot of ways how we do K through 12 education in this country in public schools. So one of the things that he talks about in his writing is how we fund public schools, for example. So you have a law that says we fund public schools based on local property tax. That in and of itself is race neutral. But if income's distributed unequally among areas of a community where people live, then you can have a racially disparate impact where students who are in poorer areas, who often happen to be students of color, have less funding for their schools than white students in other parts of a community where there's more resources and more money. And so that's one example that comes to mind of a law that is absolutely race neutral on its face. Like you have local property taxes fund your schools. But we know in this state and lots of other ones that that does tend to have a racially disparate impact. And so there are probably other examples if I think about it long enough, but anything where the law does not specifically mention race, but where the impact ends up being racially different. And so even the example with, the school desegregation and the way that that largely works. We've mostly moved away from the efforts we had in the 80s and 90s with, busing and things like that, because we decided that, because the Supreme Court decided that you shouldn't be considering students' race when you decide what schools to assign them to. Which that in and of itself is racially neutral. But it doesn't necessarily mean that everybody ultimately ends up having access to a good education.
True, I don't necessarily think of those as racially neutral.
Well, I think Bell would agree with you.
Thanks. In both of your examples, whether you're stating that it's race or not, it's, the different areas of the community are richer or poorer, more affluent or less affluent. And so if you're solely going to base the amount of, in your example, school funding to only property taxes instead of having some other equalizing force within it. I mean, the other alternative would be that everybody paid property taxes. It went into a large pool and then it was equally distributed by population.
That can happen, and there are.
And to some extent it doesn't.
And to some extent it does happen.
The larger school systems, so that you wouldn't have the hundreds and hundreds of school systems in New Jersey. You might have maybe 20 or 50.
Well, 600.
Yes, yeah.
I wasn't picking on our state in particular. Lots of states have this issue. And I think you're right that we know that the impacts of those types of laws have racially disparate outcomes. But on their face, the law doesn't say anything about race. And so I think if you think about this in terms of the context that it's coming out of, it is coming out of people who were, like Bell, civil rights litigators, who were trying to do things like school integration, when you did, in fact, have laws that said students of different races can't go to the same school. And so what they did was they broke down those laws, but under the new laws that no longer said race is the thing that we're going to decide people's educations on, you had other ways where that still continued to happen.
Well, so take a totally different example, a current example in the Supreme Court, where all of a sudden there's unlimited power to the presidency, which is in stark contrast to all men are created equal. I would think. I mean, in my interpretation, that's a stark contrast.
So we had the recent Trump v. US ruling this summer dealing with presidential immunity, which I actually thought about just doing that for this talk tonight. So what the court says is that the president's potentially immune from lawsuits for, well, the president's immune from lawsuits for official acts. They leave it largely up to the lower courts to decide what official acts are. And so there are 4 things that Trump allegedly did on January 6th. So one was he had conversations with the DOJ about what was happening that day. He had conversations with Mike Pence about not urging him to not certify the election. He called Georgia and some other states and asked them to find votes for him. And then there are also the comments that he made on Twitter and in his public speeches. And so with the case, what the court said is that his conversations with the DOJ are immune, because that was an official role of him talking to the executive branch. That's off the table. His conversations with Mike Pence are probably also off the table. They don't tell us with 100% certainly, but they say probably. When the president's talking to the vice president, that's very likely to be an official act. They say that when he was talking to the government officials in Georgia, that one's trickier because he would need to find some Article 2 power that lets him do that, which may or may not exist.
But you're taking it as a specific against, you know, the person to whom they created the law so that they could get on, you know, without being criminally indicted. But if one looks at the law, the way that law is written, I mean, what would stop, say, for instance, if Biden turned around today and said, okay, in my official act, I'm going to get rid of the Electoral College?
Well,
I mean, is there in his official act, could he do that?
technically no. So the Electoral College is written into the Constitution. So you should have to amend the document to get rid of the Electoral College. At the point that the president could unilaterally get rid of the Electoral College, we've largely thrown out the Constitution at that point. I do think the immunity case, though, is important because it is allowing the president to do a lot of things that are potentially dangerous and harmful that he cannot be prosecuted for. I wanted to go into the specifics because I think in some ways it's both broader and more narrow than the way the media has talked about it. And so he very likely is going to be prosecuted in Georgia, and that case will very likely go forward, and he's very likely not immune. Whether or not he's immune for the stuff he said on that day, the court says that depends on whether or not he was speaking as the president or whether or not he was speaking as a candidate. And I don't know how you figure that out. And the court didn't try. They punted that back down to the lower court for them to figure that out, because I guess they didn't have an answer either. But to your point, what the dissenters in that case argue is that they have essentially given him king-like powers and king-like immunity. The president, at least in the world we currently live in, can't throw out the Constitution unilaterally. I hope that's the world we continue to live in. But my answer to that is the thing that would keep him from doing that, at least in theory, is the Constitution. So it's the same thing with some of his statements he's made about wanting to be able to run for a third term, like also in the document. To change that, you would need to amend the document. And that is not a power that the president has. And it's not something that would fall under the official powers that the Supreme Court, even though they have broad and executive power, I absolutely agree with you.
Sorry, we have a question online.
Sure.
So I just wanted to get to that. Given the unintended consequences of laws that are race neutral on their face, how do we create, quote, just laws?
That is a really good question. I mean, I think what Bell and other critical race theorists want us to do is to not only look at what the law says, but to also look at the impact. I think they would also argue that we need to think about who's making the law. And so one of the things that all of these theorists have critiqued is that our institutions of government, from the president to Congress to Senate to the courts, have largely not reflected the majority of society. And so if you think that who makes the law is also an important component of this, I think they would also say thinking about who is in those positions also matters. And certainly we've seen that with the Supreme Court, that who is in those positions matters quite a lot.
Going back to the Constitution, the framers dealt with the question of democracy versus order. And could you comment on how that relates to the last question? Is it possible to create order and social equality?
Well, they certainly wanted law to create order. We know that the framers valued that highly because we were coming out of a revolution. They also baked a lot of inequality into the document. I mean, we know that for a fact. Women didn't get the right to vote until, 104 years ago? And we know that...
Actually, they did not have the right to vote. They were expunged from the vote in the early 1800s. They were excluded. Originally, there was no there. And I believe Dumas stopped and voted.
So it's actually pretty complicated if we want to get into the history of women's voting. Some states let women vote. New Jersey was actually a state where if you owned property, you could vote. Most women did not, but if you inherited something through your husband or your father and you were a property owner, you could. And then New Jersey actually rolled that back when we moved away from the Articles of Confederation to the Constitution. There are other states that did let women vote. What actually happens is when we get to the 14th Amendment after Reconstruction, women sued in states that didn't allow them to vote, arguing that the new due process and equal protection rights should allow them to vote. And what the Supreme Court said was that the 14th Amendment did not make women citizens, because women were citizens before the 14th Amendment. Therefore, citizenship and voting are not concurrent rights. And then you get the 15th Amendment where they expressly say that the right is for men, which at that point, states could, there's nothing that said states couldn't give women the right to vote in state elections, and some states did. But when the 15th Amendment was ratified, women lost their right to vote at the federal level completely. Not that I think I'm pretty sure they never had it at the federal level prior to that. But the 15th Amendment is actually the first time that women get mentioned at all. Well, they don't mention women. They say men have the right to vote. But it's also so it's interesting. They expand the right to vote for newly emancipated persons, but in the same breath, they also officially take it away from women for the first time. And so you're right. The 15th Amendment is the first time where the Constitution actually excludes women. But to your question, to my broader point, there are certainly lofty ideas of equality written into the document. There's kind of two views on that. One of them was that because this actually was much more democratic than what was out there in largely the rest of the world at the time, that they perceived what they were doing as actually creating equality. There's the other argument that says that, you know, the framers had this grand vision where they maybe couldn't create the perfect document with perfect equality at the time, but that document would live on and future generations would get to the point where we actually had that equality. But I guess what I would say is there's a lot of ways that our Constitution creates order. There are also a lot of ways that the Constitution itself and amendments to that document then later created inequality. We could also talk about voting rights for the rest of the night. The last thing I'll say on that, since you mentioned it, is part of why that case where they said that voting is not concurrent with citizenship is really important is that that precedent is also part of the reason why you can have things like felon disenfranchisement. So being a citizen doesn't automatically guarantee the right to vote. And so because of that, states actually can enact restrictions, and they do.
This is kind of a very basic, simple question, so I apologize in advance. But you know, I'm reading the questions up here and thinking about what I can do as, you know, a citizen of this country, as a community member, to make change in the law. So I was just wondering kind of what you think about that, and what you might tell your students or people, you know, who want to make change or want to make things just if they see laws as unjust. What is kind of a process for making change in that regard?
Well, probably the most obvious and straightforward, easy thing you can do is vote. I mean, and if you care about any of these issues, vote for people who are on the side of the issues that you support and agree with. And then from there, you actually can advocate and become an advocate if you want to. I mean, we have had success. And so I don't want to paint this as an entirely grim picture. I think most people would agree that we still have ways to go in terms of gender equality, in terms of racial equality, et cetera. But we are certainly in a different place than we were at the time that most of these legal scholars were putting forth these ideas. So we have made change because people have demanded it. And I think we can continue to do that. Not everybody needs to become an attorney or an advocate to do these things. But there are basic ways that you can engage in civic participation, which I guess is your next topic, that allows you to do that. I think getting involved at the community level can also really have major impacts. I think we tend to focus a lot on national elections, like the presidency, but a lot of what happens in terms of school funding, school boards, those types of major impactful things on the day-to-day lives of people happen at the local level. And it is very easy, well, not very easy, but it's much easier to impact what's happening in your town, in your community, at a local level by being involved in those decisions than it is trying to shape what Congress is doing. Not that you can't, but I do think for somebody who's not, their life goal is not to become a justice advocate, there's a lot of things that you can do in your own town and your own community that can have significant impacts.
One question, we talk about the laws and whether the laws are just or equal or race neutral or whatever, but isn't it possible that regardless of what the words of the law say, that it has as much to do with the jurist, with the judges, and with whoever the authority at the moment doing the enforcement or the guiding the process? Isn't that as important? Is that kind of what Holmes was after?
I think that is exactly what Holmes was after, that who's doing it matters. And so the Supreme Court is at its lowest approval level since we started tracking that, which is not to say that they didn't have a lower approval level before that, but we only have opinion polls going back so far. And I think part of it, if you ask people, and what the data seems to be telling us, is that we went from a society who I think seemed to have more of a legal formalist idea that it didn't matter who it was because they're only applying the law and analysis. And then once I think the wool sort of got pulled off people's eyes in a really broad public way with the last few decisions. I mean, if you're a social scientist who studies courts, no one's surprised that who the judges are matters. But I think for a lot of people who wanted to believe in that judges, you know, slip on their robes and they're neutral, or at least they try to be neutral in that role, I think some of the decisions that have come out of the court have been shocking. I also think it's partially about, you know, how some very public and nasty fights about the Supreme Court in particular in recent years have also probably contributed to that. But I think I agree. I agree that I think, one, that Holmes is saying that, but also that I do think it matters who the decision makers are.
And just one little follow-up question. What role do you think the prevalence and the rise and now prevalence of social media plays in the ability for jurists to remain neutral, or to balance, to have to use the rule of law as a ruler and not as an opinion goal? You know what I'm saying? To not be influenced. It's tough to take a beating on social media once you made it, or if you're tending toward a decision one way or the other, and to have your family threatened and to get poopy packages in the mail.
And we know that's happening, right? That Supreme Court justices are being threatened and intimidated. That's true. So a lot of the research that I've been working on personally right now, so as Greer mentioned in my introduction, I study lawyers. And so one of the projects I've been looking at is what causes lawyers to want to become judges, and looking at ambition. And what we're hearing from a lot of people is that they don't want this job because they're scared. And we hear this largely from women and people of color who are also worried about how certain decisions intersect with their identities. So, I mean, I think you're right. I think we are in a scary political climate right now, where political violence in this country is kind of becoming normalized. And I absolutely think you're right that social media amplifies that. And my guess is, as we move forward as a society, that impact probably grows. And so right now you have, you know, judges on the Supreme Court who are in their 70s. The youngest one is 56, maybe 57 now. So you have, on average, an older group of people. But I do wonder what happens as you get younger justices who are more involved with social media and who have grown up with that in a way older generations have not. And so there's certainly, for that reason, reasons to think that social media may also be impacting what judges do and how they make decisions, which is scary. But I think you're absolutely right. And that's part of, I think, why public opinion is so much more adaptive now. When a Supreme Court decision came out in the past, if you weren't really keeping up with the media and what was going on, you probably didn't even know. Now, when the Supreme Court does something, you kind of can't escape that information. It's everywhere, and you have everyone's opinions about it.
Leaks before it's even announced, you know.
No, not once.
Yeah, I don't know what's going on with the leaks.
It's a travel loop. I think somebody leaks it out to see, well, if it went this way, what would it look like? Is there gonna be a lot of blowback? Is there gonna be, people cheering in the streets, or, I don't know.
So most Supreme Court, so there was kind of the hypothesis that it was the law clerks, but that's looking less likely now. So law clerks serve for like a year, maybe 2. And so we've had leaks now from the Supreme Court across what would be a normal tenure for law clerks. So it's either a series of law clerks who are leaking this, or it's one or more of the justices, which is also a disturbing occurrence.
What would you do with a Supreme Court justice who, in her youth, 20 years from now, in her youth was a TikTok influencer? I mean, that's somebody with hundreds of thousands of followers, and it'd be fascinating to cast that forward and understand what the impact of that might be.
I mean, my guess is current Supreme Court justices could have hundreds of thousands of followers if they wanted. I mean, you could have justices who decide to have, kind of cult of personality media accounts. We haven't seen that happen.
Now you'll have someone who has a history of it already. They were in high school or whatever, and now you're thinking about being a Supreme Court justice, and 20 years, 30 years later, they're a Supreme Court justice, and now all their stuff and their makeup and their feet and their hands and their whatever and their meals are all on Facebook and TikTok. It's just a little weird to think about. What did Elena Kagan eat when she was at high school?
I mean, that's true. I mean, whether you're an influencer or not, most people have chronicled their lives from a very, very early age these days on social media.
I'd like to ask about, with respect to your first question, the Constitution holds forth the idea, at least, that the law is created ultimately by the people. And so I wanted to ask a question in the neighborhood of popular sovereignty. And I guess in the early era of this country, there was a sense that ultimately the people always rule, no matter what, and whether they do so by consenting to tyrannical government or a government that's representative is, I don't know, I guess the question is sort of where the people are at any given time. So I guess I'm wondering, in light of the survey that you gave, where is the thinking on the people these days? Is this sort of a lost political concept, or is does it have a place in each of these theoretical treatments of the law today?
So in terms of the theoretical treatments, I think it depends on who you ask. I mean, some people see the people as kind of like trapped in a box. And some of these theorists actually don't really give people a lot of agency. And so some of the more extreme critical race theorists, for example, argue that racism is never going to end. That it's always going to morph and take a different form. And that there's not really much we can do about it. And so, a lot of those ideas come back from some of your earlier thinkers about power and power structures, and how, like Foucault and others who've argued that it just takes a new form. So some of those views can be really pessimistic in terms of the role of the people. Other views argue that the people actually are the drivers, and that if the public and the people want particular changes, they can in fact do that. In terms of democracy, that's a much bigger question. I think the one thing our founders agreed on is that they did not want us to go back to the system that we had. So I don't know that they would have supported a a digression to tyranny, as they called it, if that even if that was what a majority of people wanted. But that's just my thought.
What about money in politics? When I read your first question, who creates the law? Immediately I think that people should be able to create the laws, but if we don't take the money out of politics, we'll never be able to advance towards that. So what are the possibilities? I feel like that's where we have to start.
So I think I'm actually in agreement with you. I think money in politics is a big part of the problem. So back when the critical legal studies were talking about this, it was actually less of a problem than it is now. And so the Supreme Court back in 2010 said that political campaign spending is a form of political speech and receives the highest level of, yes, Citizens United, receives the highest level of protection. And that really opened the floodgates for what we have now. I saw somewhere the other day that they've spent like just on the presidential race, $1 billion in Pennsylvania alone. And so if you think about what we could do as a society with $1 billion besides campaign advertisements in Pennsylvania. Unfortunately, the way things currently stand, the only way we could really address that is we either have a Supreme Court that's willing to overturn Citizens United, or we probably need a constitutional amendment that says that Congress can enact legislation limiting campaign spending.
Yeah.
Well, so I think this kind of gets back to his question. I mean, what's the role of the people? I mean, we can amend the Constitution. I know that sounds like a Herculean task, but we have done it before.
I've heard other countries have amended their constitutions, they have updated them, so it's not like an impossibility.
One thing our framers did to create order was they made it very hard to amend our Constitution. And so most countries have easier amendment processes that need less agreement than ours. And so part of why it's been amended so few times is that in our system, it is very hard to do. On the other hand, we have done it. If this is something that we think saves our democracy, getting the money out of politics, we could amend it. But it's something people could push for. I don't think it's beyond the realm of possibility. It is hard, very hard. But we could do that. I mean, we had prohibition. Still don't know how that happened. But we did, and we appealed it. We changed the way we elect the president and vice president. We did ensure that women have the right to vote. Like, we have done this. So it's not it's difficult, but it's not impossible. It's hard to do now, though, because we would need a majority of states to ratify that amendment.
Well, this has been a very fascinating Q&A session, I have to say. We are about at time, so if anyone has any remaining questions, Tao is here, and thank you for those who are joining us online. And again, please join us for our next session, which will be on November 13th. I look forward to seeing you all there, and thank you so much, Tao, for a wonderful presentation, and thank you all for being a wonderful audience as well.
Well, thank you for all the questions. I appreciate that.
Have a great night.
Lots of exciting.